For today's lecture, we are very honored to have with us Professor William Boothby. He will discuss today the topic of remote autonomous weapons and human agency. Professor Boothby is professor at the Australian National University, and he also teaches at the University of Southern Denmark and at the Geneva Center for Security Policy. Previously, he has served for 30 years in the Royal Air Force, and he has published widely on the topic of international law and military operations. This includes, in the context of today's lecture, notably an edited volume on new technologies and the law in war and peace, published by Cambridge University Press in 2018. Professor William Boothby will speak for about 40 to 45 minutes, after which we will have a Q&A. To ask questions during this lecture, please make use of the chat function in Zoom. We will collect questions and answer them during the Q&A after the presentation. Again, thank you all very much for attending today's event. And with that said, I would like to thank again warmly Professor Boothby for being here with us today and to give you the floor for this lecture on remote autonomous weapons and human agency.
Dr. Boutin, my thanks to you and my thanks to the ASA Institute for the invitation to come and speak. And I just hope that some aspect of what I'm going to say is going to justify your invitation. I'll do my best. Let me start by explaining that certainly much of the early part of this talk is going to be based on observations contained in a new manual that was published a year or just over a year ago, called the Oslo Manual. It's been published by Springer. It's the Oslo Manual on select topics of the law of armed conflict. And as an international manual, a number of international law experts came together in order to prepare answers to these complex, challenging issues that lie in some of the fault lines, if you like, of our subject of international law relating to armed conflict. And one of the topics that was addressed was automated autonomous weapon systems and indeed remotely controlled weapon systems and the law that applies to them. So what I would like to do is really to start by looking at the conclusions that the experts reached. And in section 3 of the manual, they address this topic by trying to look at what, as a group, we considered the likely law of armed conflict issues would consist of. And if you look through the manual, you'll see the references, certainly in the definitional provisions, to words "for the purposes of this manual." This is indicating that the experts aren't really saying that these particular definitions must necessarily apply for all time in all contexts to any international law provision dealing with this subject, but rather they're indicating, look, having thought about it, these are the definitions that we think are going to be most conducive to working out these international law questions by reference to these technologies. Certainly, it is fully recognized within the manual that irrespective of the methods or means that are used in connection with warfare, that fundamental principles continue to apply. And they are the distinction principle, the obligation to discriminate, the prohibition, if you like, on indiscriminate attacks, the core rule of proportionality, and then the obligation for attackers to undertake precautions in attack, and indeed for those in control of territory to take precautions against the effects of attacks. The law of armed conflict does not place legal obligations on weapon systems for fairly obvious reasons. It would make no sense were it to do so. The obligations of the law are firmly placed upon the people who are commanding the operations, undertaking the operations. And that's something that one has to bear in mind as we go through this presentation. So, starting with the first of these definitions, let's think in terms of remotely piloted aircraft, because we have seen over the last 20 or so years attack operations from the air against ground targets using, for instance, Predator and Reaper remotely piloted aircraft, drones as they're too often referred to. And what we've tried to do is to come up with a definition which encapsulates how those aircraft are operated. So they're an aircraft that's controlled via remote communication links by a human operator who is not located on board the aircraft. So that's putting towards the center of that particular definition the notion of this human operator having control of what is going on. So the key takeaways from this definition are that we're talking about an aircraft as opposed to a missile, and we're talking about the idea that it is piloted, it just isn't piloted by somebody who is on board the aircraft. And of course, there are various sizes of these aircraft, from the handheld at one end of the spectrum through to an aircraft of very similar size to a conventional aircraft. And of course, they have varying roles in connection with armed conflict. Then moving on, we talk about ideas of automation. And we're drawing a distinction here between the notion of automation on the one hand and the notion of autonomy on the other. So here we're on automation. A highly automated weapon system is one that, once activated, is capable of identifying and engaging a target without further human input. So it will be capable of making those decisions on its own. And the thing that characterizes it, the feature that characterizes it as being automated as opposed to autonomous, is this element of being constrained by algorithms that determine its responses by imposing rules of engagement and setting mission parameters, which limit its ability to act independently. So what we're talking about here is a weapon system where there are constraints imposed within the structure of the system, such that it can't do as it may choose. It is required to behave, if you like, in accordance with these previously imposed constraints, limiting its discretion, if you like, its ability to act independently. Okay, so that's what lies at the key of this idea of automation. And then we move on to autonomous weapon systems. Now, I stress that we're almost at the moment in a situation where you speak to 5 experts and you will receive 15 different definitions of autonomy. The version that we came up with for the purposes of the manual is as follows: that it's a weapon system that is programmed to apply human-like reasoning, not human reasoning, but human-like reasoning simulating the reasoning that a human being would apply, would undertake. Human reasoning to do what? Human reasoning to determine whether an object or a person is a target, whether it or that person should be attacked, and if so, how and when. So here you have the key distinction, if you like, with automation, because here you have the application of reasoning according to which the autonomous weapon system is making a determination. The determination that this thing or this person constitutes a target, and then the system goes on to determine how and when to attack it. Okay, so the focus is on human judgment, and it's a process, this idea of human judgment, in which various facts are assessed and they may be compared. But the purpose is to reach, and I think the big word is evaluative. The purpose is to reach an evaluative decision or determination. And judgment is core to the process of achieving that determination. And then in the final bullet, I point out that such technology is not yet known to exist, but it is perfectly clear that this is if you like, the goal in the direction of which current development processes and scientific development processes are aiming. So with automation, if you know the algorithms and you know the thing that is stimulating the machine, if you like, what the machine is seeing, then the chances are that you are going to know the kind of response that you're going to get from the system because of the constraints imposed by those algorithms. Whereas with autonomy, the weapon system is making relevant judgments by applying this human-like reasoning. That's the formulation we came up with for the purposes of the manual. But I ask myself, must the reasoning process necessarily be human-like? Or is it just the necessity that a reasoning process leading to a decision is what is called for, whether or not it replicates the approach that a human being might adopt? Certainly, there must be an ability to analyze information, and certainly there must be an ability to make a determination. Either, yes, I'm going to attack it, or no, I'm not, or I'm going to attack it this way, or I'm going to do it that way, or whatever. But the focus, as I indicated earlier, I think, is on evaluative decision-making. Now, there are certain kinds of terminology that you will frequently encounter in this context. If you find people talking about man-in-the-loop weapon system, well, these are the systems that I was talking about earlier, the predator and reaper type systems, where you've got a human being who is within the loop formed by the decision-making process in the system, so that it's that human operator who then decides on the firing of the weapon. So therefore, the human operator is, if you like, the agency through which law, for instance, is complied with. A variation of that is this notion of man on the loop. Very politically incorrect, ought to be person on the loop, POTL. This is a system which is capable of either highly automated or autonomous operation, but is supervised by a human operator who has the ability to intervene, if you like, to wave the red card and to override the either automatically or autonomously made decision, such as the decision to fire a weapon. So what you need, if you're going to have this man on the loop type of system, or person on the loop type of system, you need the ability to observe what the weapon system is actually doing, and then to intervene and countermand if that action is deemed to be necessary. So what about this man on the loop system? Well, the law of armed conflict doesn't actually specify a requirement that there must be a person on the loop of a highly automated or autonomous weapon system. There is no specific rule to that effect. The human on the loop may, however, help to try to ensure that targeting law rules are complied with. So that can be a positive feature particularly if you're thinking of employing autonomous weapon systems. However, it seems to me that the positioning of that individual, the tasking of that individual are going to be critical, because if you were to have one individual who is the so-called human on the loop of 15 different systems all operating independently of one another at one moment, then the degree of supervision that in practice is going to be applied by that individual is going to be very questionable. And equally, if you've positioned the individual in such a way as not effectively to be in a position to intervene, then the notion of that person being on the loop also becomes somewhat problematic. But the countermanding by the man on the loop may well be for legal reasons, because the person observes that the system is about to make an attack decision which will be unlawful, or it may well be for commander's intent reasons, where it becomes evident that the machine is about to undertake an operation which lies outside the scope of the purposes set by the commander in advance of the operation. Another concept that we thought about was swarms, not bees, but swarms in relation to weapon systems. And we came up with a definition that a swarm would be a group of aircraft or other vehicles. And I stress the or other vehicles throughout the topic that I'm covering. Clearly, unsurprisingly, given my background, I tend to think in terms of aircraft, but self-evidently, the technology that I'm talking about applies on land, in the air, on the surface of the sea, and indeed subsurface of the sea, and potentially in other environments, such as outer space, such as cyberspace. But leaving that point for a moment, the swarm idea is a group, say, of aircraft of any size that is performing, the swarm is performing, or is intended to perform military tasks where the individual aircraft or vehicle is autonomously coordinating or acting in formation, or are acting in formation. So what you have is a degree of autonomous or maybe automated technology, ensuring that what each member of the swarm is doing takes account of the activities of the other member of the swarm. Hence, if you go online, you can see footage of swarms of small aircraft dancing around, for instance, in formation. Well, that sort of idea, but in the operational context, obviously developed significantly. The distinctive element is the use of autonomy, or I think automation, to coordinate the swarm and indeed to distribute tasks to the individual members of the swarm. You could have one that's involved in reconnaissance, for instance, another one that's involved in attack, and so on and so forth. And then this coordination can in part be purely to avoid collisions amongst the members of the swarm. But the point, I suppose, is that in defining swarms in the way that we have, we've tried to leave open the various forms in which swarms may, in the future, expect to be organized. So, a basic proposition of law is reflected in Rule 41 of the manual, and that is that the employment of any of these technologies for the purposes of attack is subject to the law, i.e. the applicable principles and rules of the law of armed conflict. And in particular, these would be the principle of distinction, proportionality, and the obligation to take feasible, in other words, practically possible precautions when making decisions in respect of attack. So limiting, if you then think in terms of an autonomous weapon system, it may well be possible to use autonomous weapon systems in accordance with existing law, provided that the human operators so limit the geographical space within which the autonomous system is conducting its search, and the periods of time during which it is conducting its search, such that all attack solutions, if you like, all attack decision making by the autonomous system will of necessity comply with the core rules and principles of the law of armed conflict. Why? Because you, as the commander, as the operator, have decided, have checked in advance what is going on in the relevant area and have satisfied yourself that that will be the case. Otherwise, the question then that has to be raised is whether the system can be used in a way that will adequately distinguish between lawful targets on the one hand, military objectives, directly participating civilians and combatants, and on the other hand, civilians and civilian objects. Can, in other words, the weapon system be used in a way which ensures that, so far as you can ensure, that only lawful targets will be made the object of attack? Now, there is no provision of the law of armed conflict which is prohibiting the use as such of remotely piloted aircraft, autonomous systems, automated systems, and swarms. There is no ad hoc provision of law prohibiting those technologies. That's why it becomes important to assess whether the underlying core rules of targeting law can be complied with by weapon systems where you are increasingly taking the human being out of the system itself. So how do we go about assessing new weapon systems? Well, existing law is the basis for judging the acceptability of new and emerging weapon technologies. It isn't a situation in which, because it's a new weapon technology, therefore we can dispense with certain provisions of the existing law. Oh, no, no. The weapon technology has to be compliant with existing law. And there is an implied obligation placed on all states, whether they happen to be parties to a particular treaty or not, to determine whether the new weapon systems that they're acquiring comply with the international law obligations by which they're bound. There is a more extensive obligation placed on the vast majority of states, 174 in fact, that are party to the first protocol additional to the Geneva Conventions. That's the first of the two protocols dated 1977. That provision, Article 36, requires that there be a formal legal review in the study, development, and acquisition of new weapon systems and in the adoption of new ways of conducting the hostilities. Okay. So when you are studying technology with a view to its weaponization, that's when the first obligation to conduct some sort of legal assessment arises. What are the criteria that you apply when making that determination? Well, you judge, first of all, whether the weapon system is of a nature to cause injury or suffering for which there is no corresponding military purpose. You ask yourself, secondly, whether it's indiscriminate by nature. Thirdly, you look at certain environmental protection provisions, which only bite, generally speaking, if the environmental impact is particularly severe. But nevertheless, you judge whether the weapon system is either intended or maybe expected to breach those requirements, and then you ask yourself whether there are any ad hoc rules of weapons law addressing the technology in question. So evaluating autonomy, how do we go about doing that in that sort of weapon review, if you like, context? Well, you recognize first, I suggest, that human-like reasoning and evaluation decision-making are likely to challenge the current technology that is presently available, i.e. that the chances are that the technology that we've got won't, in practice, be able to undertake the kind of reasoning and evaluation that the law actually requires. But on the other hand, looking to the future, one can imagine a situation in which you're dealing with a technology which doesn't have fear, doesn't panic, doesn't experience anger, tiredness, the wish for revenge, and so on. It just does as it's programmed. And therefore, maybe some of the failings of human beings on the battle space can be addressed by adopting technology of this nature. And it's conceivable, I suppose, in the future that this sort of technology, this sort of autonomous technology, could outperform human beings. But, and it's an important but, there are certain decisions that the law of targeting requires be undertaken prior to attacks taking place. And first of all, one of the important rules is the proportionality rule, the prohibition of deciding to undertake an attack where you expect the civilian injury and damage to be excessive in relation to the anticipated concrete and direct military advantage. Equally, there are certain persons and objects that get special protection under the law. Can the weapon system determine this is a specially protected object, which means I'm required to comply with certain additional rules? Can the system distinguish, for instance, between soldiers who are able-bodied and able to fight and soldiers who are rendered defenseless by wounds or sickness and who therefore are must not be made the object of attack in accordance with Article 41 of Protocol 1? Can the machine decide whether a warning is required under Article 57 of the protocol? Can it indeed decide in accordance with the required precautions in attack set forth in that article, Article 57? Can it, for instance, decide that actually there is an alternative target that I could be attacking, which would produce the same military benefit for less risk to civilians, therefore I should be attacking that? These are all very difficult evaluative decisions, which one rather doubts that existing technology is capable of matching. But the Article 36 issue is going to be whether the design of the weapon system is going to be such that targeting law is capable of being complied with. Not will a particular attack actually comply with targeting law, but actually can the technology apply targeting law at all and sufficiently. So, how satisfactory is this weapon review process from a global perspective? Well, there are drawbacks, to be fair. It involves an element of self-policing in the sense that it is the state itself that is reviewing its own decisions about acquiring weapon systems. And there are those who regard that as being an unsatisfactory way ahead. So is it sufficient? Is it sufficiently acceptable? Some say yes, some say no. But then think through, if it were to be regarded as inadequate, would would scientists or manufacturers and their ethical codes be any better? I rather doubt it. The main issue, certainly, I think, where machine-decided killing is concerned, is the ethical issue rather than the legal issue. It's how ethical is it that a machine decides who is to be attacked and who is to be spared? And then the second issue, however, is a realization, I suggest, that human decision-making is going to be particularly poor when digital speed is what is required. It's one thing if you give the human being sufficient time to consider. It's quite another thing if the inbound threat requires an instant, pretty much off the cuff decision. So where is the balance of advantage? I don't know. I'm going to raise a few questions rather than necessarily provide the answers. So what is different? Well, we've got a targeting law focus. Okay, that's clearly going to be critical when we're evaluating these new systems because of the absence of the human being in or on the loop. And the challenge for anyone reviewing these technologies is going to be to understand them. And arguably, the traditional tests about the degree of suffering and the environmental impact and so on and so forth are going to be of, shall we say, lesser relevance, arguably, than in connection with more traditional weapon systems. How far should ethical considerations affect your judgment? The Article 36 requirement, the weapons review requirement, is to apply law. But on the other hand, inevitably, there is going to be at least a consideration of the acceptability or otherwise of the ethical aspect. Will future peacetime law regulate autonomy? And will or should it apply to weapons? That's an open question. There are discussions going on in Geneva at the moment under the auspices of the Conventional Weapons Convention. And the topic they describe as laws, ironically, lethal autonomous weapon systems. Whether specific legal provisions, legally enforceable provisions, will emerge from that process is an open question. I have my doubts. So what is the basis for the advice where the law itself is controversial? How do you as a lawyer decide what advice to give in relation to a weapon system where you cannot know all of the answers because actually the underlying law is still a matter of discussion? Well, I would suggest that you come back to certain basic propositions: distinction, discrimination, proportionality, and precautions, those rules which I've already mentioned. Arguably, the Martin's Clause, not as a criterion of acceptability of weapons in its own right, but as an indicator that customary rules continue to apply and must be considered. Does the law presuppose a human being undertaking the required decision-making in targeting? I would argue not. You see, if you look at Articles 51 and 52, and you'll see shall not be the object of attack. And if you look at Article 57 with its precautions and its reference to shall be taken, the use of the passive mood actually, in my view, leaves open the possibility of the decisions being taken by something other than a human being, and would suggest that the law is being written as a law requiring results rather than a law prescribing who is to achieve those results. So what are the implications? Do weapon reviewers need to have greater technological support and understanding? I suggest yes. And I suggest in practice, what they're going to require is input from specialists in order to determine whether the weapon systems that they are considering with a view to procurement actually do satisfy the legal requirements of that state. Will operational lawyers need weapons law training? Maybe, in order fully to understand the weapon systems that they are acquiring, and arguably, actually, not just them, but also commanders will require sufficient technical understanding to know the parameters of the decisions that they're making. Will scientists be able to predict the performance of what they produce? Not necessarily, which then raises the question, can states agree on how existing law applies to new technology? And if they can't, what's the situation then? Arguably, not entirely satisfactory. And can these weapon systems be tested adequately? Because let's face it, if you are procuring the weapon system as a state, then the responsibility falls fairly and squarely on your state to do the testing and then to become aware of whether the decision-making of the weapon system is acceptable or not. So how can we be sure, and here are just one or two questions for you to ponder maybe afterwards, how can we be sure what lessons artificial learning intelligence is going to learn? Is unconstrained artificial learning unacceptable? I suggest maybe it is. Can we be sure that artificial learning intelligence is going to limit itself to the permitted lessons, and indeed to learning those lessons in the permitted way? I mean, it may be that we decided that we didn't like the issues raised by the first two questions, and therefore that we were going to constrain the lessons that the artificial learning intelligence is permitted to learn. Okay, so we constrain it, but are we sure that the weapon system is going to stay within those constraints? Have we, if you like, hermetically sealed what it is permitted to learn? Is it indeed going to become a legal rule that the permitted lessons are limited? And indeed, are the limitations going to become part of a specific rule? And is there going to be any customary law on this? Will practice develop sufficiently to establish customary rules? I suggest only probably very slowly. And bear in mind, states do bear responsibility for internationally wrongful operations which are attributable to them and that use such weapon systems. So international responsibility considerations don't stop at the door of automation, autonomy, swarms, and so on. All who are involved in conducting operations of this nature using these weapon systems are responsible for their respective roles and commensurate with their involvement. That's the phrase that we used. Okay, so your degree of responsibility is inherently linked to what your role is, and indeed what your responsibilities are. On the other hand, that therefore puts the ball fairly and squarely in the court of the commander. The commander has clear responsibilities here, and therefore commanders are going to need, in my view, to have very clear understanding of how the weapon systems work, what their flaws are, and so on and so forth. Which feeds back, of course, into the obligation to undertake testing and to evaluate the system properly before procuring it. Some closing thoughts. Agency is one of the terms in the title to this talk. Agency, it seems to me, is a person or a thing that acts to produce a particular result. Human agency doesn't presuppose a man in the loop, or, in my view, a man on the loop. You can have human agency by virtue of the way in which you configured the system before sending the platform, whether it's a submarine, whether it's a surface ship, an unmanned surface ship, whether it's an aircraft, whatever, before sending the platform out on its mission. How remote can a human be from trigger pulling and still be seen as an active agent? Now, that may be something that needs to be defined when emerging law is drafted, but I don't think it's going to be a terribly easy phenomenon to draft. Is the place where the human is, or is it how causally involved the human being is in what is taking place that's the main issue, the main concern? It may not be a geographical thing. It may not matter that the operator is way back on one continent where the operation is actually taking place on a different continent. Probably what matters rather more is the causal connection, the causal link between what the human being is doing and the ultimate performance of the platform. And then the final question that occurred to me, if speed in terms of the inbound threat requires a digital response, how do we go about dealing with that situation in legal terms? Do we ignore the threat and merely craft a prohibition on the technology that aims to respond to it? Or do we try to prohibit the factor, if you like, the capability that is producing the speedy threat? Or do we say to ourselves, actually, stopping scientific advance isn't something that we've been terribly successful at up until now. Why do we suddenly imagine we're going to succeed in this context? Maybe we just accept that this is the direction of scientific advance. I think that's what I had to say. And I hope I finished roughly on time.
Thank you so much. Timing is perfect. Thank you really for this very insightful lecture. I think you approached the topic very well and convincingly, and especially your last point on speed is really something that many people should be thinking about a little bit more. So now we have some time for Q&A. Please let me recall to the audience that to ask questions, please use the chat function, and I will go through the question and ask them to Professor Boothby. So there are already a number of questions, and let me briefly scroll up so that I can see. All right, so to start with, we have a question from David Kohler, who asked a question about the, what kind of threshold do we use against autonomous weapons when it comes to distinction and recognizing between civilians and military targets? He explains that human decision-making is quite imperfect in itself. So if we develop technology that is able to distinguish between civilians and military objects with, for instance, XY percentage of accuracy, what level of accuracy can be acceptable in terms of law of armed conflict, if you see what we mean this question?
Yeah, the problem, excuse me, the problem with international law is it doesn't measure things in centimeters and meters and feet and inches. And therefore coming up with a numerical basis of acceptability, if you like, criterion of acceptability, is not going to be possible. Secondly, one of the core rules that applies, in fact, the core rules that apply, first of all, the principle of distinction, shall direct their operations only against military objectives. So we're talking there about the requirement of the decision makers to consider all information that's reasonably available to them, to make the decision as to whether or not the particular person or object is a lawful target, if I can put it in those lay terms, and then to only target the individual if that individual is found to be a lawful target. Now, that begs, if you like, the question that you've raised. And I think that it's widely accepted that the decision making that needs to be taken is that will be the decision of a reasonable military commander in receipt of the information that the particular decision maker has available to him or her. And if that reasonable military commander would say, "Yep, I'm good to go," then that is going to be an indicator that the decision to attack is going to be lawful. And that would certainly apply if you are looking, for instance, at the proportionality test, at determining whether the collateral injury and damage is going to be excessive in relation to the anticipated military advantage. But the requirement certainly, though, is to consider all available information. And so you can imagine a situation in which you have a human being wrestling with vast amounts of information coming in and suffering from information overload. Contrast a machine which would be capable of sorting, sifting, and categorizing the information, to quote the phrase I used during the lecture, at digital speed, and therefore reach, shall we say, a rather more rapid decision on the basis of having considered all of the information that actually has been made available to that machine. So that's the way I would express it, but I wouldn't express it in terms of specific percentages because the law doesn't do so, and I think percentages are capable of being misunderstood. There is a large contextual element in all decision making to do with targeting, and that has to be fed into any discussion.
Thank you. And I fully agree with your perspective on this question, but it's also a question I've seen raised in similar terms in many different platforms, because from the technological side, people tend to see the results in terms of percentage. So they ask how it fits with the law of armed conflict. Yeah. But moving on to another question, Claudia Klonowska asks whether you would mind further explaining what do you see as the main objective of distinguishing between military decisions and judgments? She further asks, do you think that we could refer to machines' decision-making as exercising judgment?
Yeah, okay. I've been doing writing on this for too many years, and and increasingly I'm getting into trouble with those who accuse some of the words I use of being, now I'm going to get this word wrong, it's a horrible word, it's anthropomorphizing the concept. In other words, I'm being accused of applying to a machine notions which are peculiarly human in nature. Now, the problem is essentially as follows. If we are talking about true autonomy, if we are talking about a machine where the machine has the decision-making process and it decides without human involvement, then it seems to me to follow logically that one has to ask, is that machine capable of applying distinction, discrimination, proportionality, and precautions? Can it, in other words, comply with the law of targeting? Not just comply with it, but can it actually apply the law of targeting? It's at that point that I know certain American commentators raise their hands and say, wait, stop. Machines, there are no legal rules that require machines to apply the law of armed conflict. And I then, from that, forgive the use of my hands, but say, okay, but if you are telling me that you have removed the human being from the decision-making process, and if you have sent out, theoretically, this machine into the battle space to go and see, which could be anywhere, to go and find its own targets and decide when, where, and how to attack them, then I say to you that the minute you've taken human beings out of its decision-making process, the only question that you're left with is the question, can the machine do it? Because ultimately, it seems to me that the decisions in the law of targeting are decisions that have to be taken. And if they're not going to be taken by a human being, then are they going to be taken by the machine? So it's on that basis I come back to say to you, yeah, in machine-based decision-making, if you have taken all human decision-making away, if you don't have this situation I described in the lecture where, you know, say you're going to send the machine off to go and search in an area of desert, where you know jolly well that if there's any vehicle in that area of desert, it's going to be an enemy military vehicle because it's so remote and that's where they are. Excluding that sort of situation, the more normal congested battle space type situation, it seems to me that the question then becomes, if you're wanting to use autonomous technology autonomously, the question then has to be, can the machine make the decision? Now that's controversial.
Yeah, no,
but it's my view.
Yeah, thanks for explaining it so clearly as well. I would like to raise another question, which is slightly related to the previous one. This question is from Professor Lisbeth Leinzat. And she says the question you have raised concerning whether the law requires the participation of a human being is important, as it is both a philosophical as well as a legal matter. But she's not convinced that your reading of Article 51 and 57 is correct, noting that it is unlikely that the diplomatic conference considered the phenomenon of autonomous weapons. And she adds that, that it is in the end not about the semantics of IHL provisions, but rather about the protection and the possibility to intervene in military actions when development urgently requires you to do so. So to her mind, this is a stage prior to international responsibility.
Mm. And I very much respect that point of view. And I'm not sure that I'm disagreeing with you, actually, to be perfectly honest. I absolutely accept that notions of autonomy were not reflected in Protocol 1, for instance. I'm inevitably, if we're looking at how Protocol 1 provisions relate to a new and emerging technology, then the first point is the point that I made in the lecture, namely that whether those developing the technologies like it or not, the fact is that it is existing law that provides the yardstick for acceptability. And therefore, what we have to do is to look at existing law and ask ourselves, can this be applied consistently with notions of autonomy, for instance? Now, I've said in answer quite clearly. Current technology, the answer is no, in my view, because the autonomous technology can't make the decisions that are required by the law. On the other hand, if one were to move forward, I don't know how many decades, imagine a situation in which autonomous decision making had been improved considerably. And imagine that you have a position in which a machine can differentiate between civilians, combatants, peaceable civilians, and persons acting in such a way as to represent a threat, and can do it better than a terrified 18-year-old soldier armed with an automatic weapon who has been sent out on patrol in a relatively hostile area to which he has been deployed. The question then is, if that machine-based process were to be able to decide not to empty the magazine in a particular situation, and as a result, not to kill 15 or 20 civilians unnecessarily, how many unnecessary deaths would we be prepared to put up with in order to satisfy our preference for human decision making as opposed to mechanized decision making? Now, that's a hypothetical time in the future. I'm not suggesting that we're there now. But on the other hand, technology does advance, not always in a straight line and not always in the way that we would like. I'm the first to accept that. But nevertheless, to exclude a category of technological development on the basis of what we see at the moment, and without leaving open the possibility of development in the future, might, in some people's eyes at least, be seen as not entirely satisfactory.
Thanks. To move on further, there's a few questions related to Article 36. So I will try to bundle up them together, and they're also a bit more on a concrete level. First, you mentioned how the process of the legal review applies when technology is developed with a view of being used in weapons. However, with AI technology, many technologies are developed without a specific purpose, without a specific military purpose. So how can we tackle these aspects with a weapons review? Secondly, you noted how Article 36 relies a lot on self-policing by states. So a question is whether there should be some sort of standards agreed upon among states, perhaps sharing best practices in a way that will make the review process a little bit more transparent and reliable on. And finally, a question relates to the role and the implications of the principle of humanity as one of the considerations to be taken on in the context of Article 36. To which extent is this principle relevant and applied to during the review process?
Okay. First point, absolutely right. A lot of AI is going to be developed in the civilian sector. If you were to go back, say 30, 40 years, the weight of technological advance was very much more in the military sphere, because arguably that's where the money was. Whereas increasingly now, the money is in the hands of civilian consumers, and therefore technological advance quite a lot of it, is at that civilian commercial level, and the military are therefore, if you like, asking themselves, how can these advances be applied in the military sphere? So you're right, I agree. How does this interact with weapon reviews? In my view, at the point when a state is studying the potential application of an emerging technology for military purposes, the legal weapon review, Article 36 obligation applies. And that's the point at which a weapon review assessment needs to take place. Would it be a good idea if standards were to be agreed upon, sharing best practices and achieving greater transparency? Let me attack that backwards by starting with transparency. If you are reviewing a new weapon for your state, you have a considerable interest as a state in keeping the technological performance of the weapon, for instance, which is going to be a key factor in the weapon review process, keeping that confidential. You are not going to be interested in anything that is going to have the potential effect that a potential enemy will get to know more about your new weapon systems than you wish. On the other hand, I see every, I think it would be very desirable if best practices in terms of how to conduct weapon reviews were to be shared among states. And certainly a few years ago, the Doctrine Centre, where I used to work many years ago, down in Shrevenham in Wiltshire in the UK, ran 2 or 3 international conferences talking specifically among states about how to address challenges in the weapon review arena. And I would advocate that. I think that's the sort of state engagement process which can be highly beneficial and should be recommended. But on the other hand, there is a certain reluctance on anything that is going to disclose particular technologies, particular interests in particular technologies with specific states, and so on. So one has to respect those sensitivities, it seems to me. The principle of humanity, I think the principle of humanity is always relevant. However, I would put it like this. The way I interpret the principle of military necessity and the principle of humanity is that they are 2 underlying philosophical notions which are in tension with one another. One being an essentially enabling process, i.e. the permission to use such force as is necessary to defeat the enemy at the earliest possible moment with the least expenditure of resources. And the other of which is essentially prohibitive in nature, i.e. you must not use weapons in breach of the principle of humanity, putting it in very brief terms. And as I see it, this is just my conceptual approach to this, those 2 philosophical notions underpin the whole of the body of the law of armed conflict, and it is where the tension between them plays out that determines the body of law as a whole. And therefore, what I don't think states do is then to pluck out the principle of humanity and to think of it on its own in isolation as something that needs to be brought to bear when considering a particular weapon system. What they would do is apply it by applying the principle of superfluous injury, unnecessary suffering. In other words, they would look at the injuring mechanism and the suffering to be expected from the application of the new weapon in its normal and intended circumstances of use, and they would then determine whether there is a degree of that suffering, a degree of that injury, which is unnecessary in that generic military context. That's, I think, the correct approach. And it's into that test, that superfluous injury, unnecessary suffering test, that the principle of humanity comes in the weapons context.
Thank you very much. With these great words, I think it is soon time to close the event. We've used all of our allotted time. So thank you so much again for your really, really interesting presentation and for engaging with all of the questions from the audience.
Okay.
Thank you also very much to our participants for all their questions in the chat. There are a few questions we didn't have the time to ask, but I think we already had a very, very interesting discussion. So thank you to you all. I just want to briefly note that the next lecture, the DILEMA Lecture series, will take place on the 23rd of March. So please mark down the date and keep an eye on our website for registration information that will soon be available. And with this, yeah, I think we can close this event and with, again, warm thanks to our speaker of today.
And thank you from me, Berenice.
You're very welcome. Have a good afternoon and evening.
And you do the same.
Goodbye.
Cheerio.